All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for enforcement of children's rights. Before I
Jorge, I cannot
introduce our
hear you.
speaker, you cannot hear. Can you hear me, Christine?
Yes.
Okay, Robin, there might be some issues with your audio, but okay, I guess we're good to go. We'll double check later. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded, so you're going to receive a copy of this recording from Zoom within about 24 hours. We will also be posting it on YouTube, so I'll drop the link to our YouTube channel and to the specific playlist for all these webinars that we've done in partnership with Florida's Children's First. The training was approved by the Florida Bar for 2 general CLE credits, 2 civil trial certification credits, 2 appellate practice certification credits, and 2 juvenile law certification credits. So I'll drop the CLE code in the chat towards the end of the presentation. I will also include the CLE in the YouTube description as well. So I'm looking at the chat to make sure that people can hear me. I see some people saying that they can hear me, so we should be good. If you need a certificate of completion or attendance, feel free to email me after the webinar is done. Usually what I do is I let a few emails pile up so I can start getting them out all at once. If for whatever reason you emailed me and I missed out on your email, don't worry. Feel free to keep bothering me and email me until I give you your certificate. So closed captions are enabled for anybody who needs them. So if you're having any issues with accessibility or the captions, you can reach out to me directly. And the materials, the copy of the slides are going to be emailed as well after the webinar. I will include a link to a shared folder where you can find a copy of these slides. So if you have questions during the webinar, please use our Q&A feature. We're going to have Robin try to answer some of the questions as they come in. If for whatever reason we can't get to a question immediately, we'll try to answer any remaining questions towards the end. This training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. If you're not familiar with PILS, I'm going to drop a link into the chat so you can take a look at our website, take a look at our working groups, and in particular, take a look at our children's rights work group. And the reason I mentioned the children's rights work group is because I'm going to pass it over to Robin Rosenberg. Robin is the deputy director with Florida's Children's First, and she is the chair of the Amazing Children's Rights Work Group. So, Robin, I'm going to pass it over to you so you can say a few words and introduce Christine. Can you hear me, Robin?
And yes, fortunately, I was able to hear you. Thanks, Christine. Can you next slide, please? Just real quickly, show the. Really, I'm not the speaker today. I just have some introductory remarks, and Christine Smith will be the main presenter. There are a couple things that I wanted to share with you. So first, my name is Robin Rosenberg. I'm the Deputy Director of Florida's Children First, and very excited to have the team of lawyers who are presenting this training series that this is a part of. One of the things that we do to share information and to support all of the lawyers and judges who work in the child welfare arena is to run the Florida Dependency Law Center website. It is a free resource for attorneys and judges only, and you do have to register to be a user, but there are a lot of resources on that website, and there are also communication tools, and it's a way that we can communicate with everybody about upcoming trainings, events, what's new, what's happening in the legislature, what's happening nationally, different information. So if you're not currently a registered user, I encourage you to register to use the Florida Dependency Law Center website. Next slide, please. And while we're putting this out, I think, Jorge, if you'll launch the initial poll to find out who's here, that would be great. The last thing I wanted to talk to you about is our upcoming trainings. We announced this training series and began, I forget, September, October, I think. And we have decided to continue our trainings on the third Wednesday of every month. Next month will be Erica Herring and Patty Alton presenting on disability application basics for children and youth. And this is really intended to are we really need to get in and do our SSI applications, and how do we do them right? And then the remaining series starting on April 15th. What we've given you is the topic that's going to be addressed in the training series. The title will be decided closer in time as the material comes together. But so if you just mark your calendar for the third Wednesday of every month, we have something great to offer you. And as always, if you can't attend at the day of the training, if you go ahead and register, the video will be sent to you along with a link to the materials. So we really appreciate all of you attending and hope that we're providing you something of value that you can use in your everyday work. At this point, I would like to turn it over to my colleague, Christine Smith, who has been working really hard educating young people about their rights and helping the lawyers and guardians ad litem that work with those young people get those rights enforced. So, Christine, take it away.
Thank you so much, everyone. I appreciate you tuning in and for caring about children's rights. We did a series of Know Your Rights for youth in care, and then there was one tailored that we gave a few months back. I believe it was in September on Know Your Rights. So this is going to highlight some of the rights, but there's a more robust presentation out there that this is sort of part two. There was an interest in enforcement. So this is sort of the sequel to that. And I just highlighted a few of the rights. This is not by any means a comprehensive enforcement of all of the rights outlined in that. But it's more nuts and bolts techniques on how to enforce those rights. And I would like to preface the whole presentation with I've been practicing independency since I got my bar license in 2007. That's 19 years just about. And I've only done one motion for contempt. Most attorneys, when they think about enforcement, contempt comes to the top of the list. And we'll talk about that later. But really, my presentation today is how to get those rights before it ripens into a contempt, sort of a holistic approach on how do we get those rights enforced as we go. And sometimes you can't help anything else but a contempt motion, but we hope we don't get there. So with that, right to counsel is one of, as a children's attorney, I'm biased towards kids having a right to counsel. I'll put that up there out front. Not to say that we're better than anyone else, but I do think that it is important for a child to have their own attorney. It's a different role than the guardian ad litem. And so under the statute, there's a right to an attorney for a child under 5 categories. And those are listed here. If a child is being considered for placement in a nursing home, if they have been prescribed psychotropic medication and they don't want to take it, or they're too young to weigh in on whether they want to take the psychotropic meds, that's another category. They have a diagnosis of a developmental disability. I get a lot of appointments for autistic children. That's one of the categories. If a child is being considered for placement in a residential treatment center, that's another category, or a victim of human trafficking. And I'll just give a plug. We gave, Pills gave a human trafficking CLE last month. So you can go to the website and pull that up if you're interested in that. And if you're in court, or you know of a child, maybe you're a case manager, and there's another child on your radar that doesn't have an attorney ad litem, what do you do? How do you make that appropriate referral? You can bring it to the court's attention and ask the judge to appoint an attorney ad litem. The judge has inherent authority to appoint an attorney for a child at any stage of the proceedings. Sometimes I'll get an appointment later on in a case, maybe because there's a nuance with the child's adoption, or maybe there's some a conflict between the siblings and there's a sibling separation. And so it may not come to light that a child may benefit or may need an attorney. You can email the Children's Legal Services Division Chief and make that referral. Robin sits on the Juvenile Rules Committee, and Children's Legal Services said that's how they would like to be alerted. So when you get these slides, there is a link. That little link symbol to the lower left is a link to our website where it lists the division chiefs by county or by circuit, so that you can make that referral to the Legal Services Division Chief. You can contact your local legal aid to see if they can make a referral. We're kind of Florida's Children First. We're an organization that is statewide, so we are not in every single county as a physical presence, but we will see if local legal aid will get on a case before we will jump on a case. We're kind of filling in the gaps where there might not be another attorney from legal aid to fill those gaps. And then you can always contact us to see if it's an appropriate referral. And it doesn't have to be under those 5 categories. Again, because the court has inherent authority to appoint an attorney ad litem, it can be for anything, and the judge will make that determination. But you can contact us via our website, which is on just about every slide, and you can make a referral, and we will screen it to see if it's appropriate for us to get on the case, or for us to refer to maybe another legal aid. So with that, I'll get to the next slide. And Jorge, if you could put the next poll up on, have you ever tried to help a child that's entitled to counsel on those 5 categories? Have you ever tried to get an attorney appointed? We're interested in tracking that because it's a mandatory appointment. I'll go back one slide, because under those 5 categories under the statute, it's a mandatory appointment. Oh, I can't go back one slide while the poll's up, but that's okay. You guys were paying attention, I know. And so the question is, have you ever tried to help a child that's entitled to counsel get an attorney appointed for them? And we have some answer choices. I don't know any children in that situation. I know some, but I haven't tried. Yes, and I have been successful. Yes, and am successful every time. And yes, but never successfully, which would be sad to me.
We have about 60% participation, so I'm going to go ahead and end the poll in 5, 4, 3, 2, 1, and let's go ahead and share the results.
So a lot of people say, I don't know any children that in that situation. I would encourage you to review the statute on disabilities. Maybe it's because it's one of the categories that I see a lot of children in care with disabilities. But I would say that there are a lot of kids out there that are being underserved. So good news is that between the 3rd and 4th answer choice, some have been successful sometimes and some successful every time. That's good news. That's a lot of kids with getting attorneys. And yes, but never successfully. That's good that it's in the minority. And that's a positive thing. Not positive that 2 kids went without attorneys, but positive that it's in the minority. So we'll switch gears and we'll talk about right to privacy under Chapter 39. Enforcement begins with disclosure. Just because you know it doesn't mean you have to share it. And again, I'm coming at it from an attorney for a child perspective. We have the traditional attorney-client privilege model, which means that if I'm meeting with a child and they tell me something, not only do I not share it unless I'm specifically authorized to But I want to make sure with my child client when it is okay to share and when it's not okay to share. We're talking about kids in court all the time, but I think it's important to remind ourselves that just because the child tells you something or just because you know something does not mean that that you have to say it, and particularly does not mean that you have to put it in the court file or say it in court so that it's on the court record. Once it's in the court record, it will be shared with everyone who has access to the court file, which can be a lot of people. So I would caution you just to keep that at the forefront of your mind. Even folks who don't have that client privilege, I think it's always to respect the autonomy of the child, to ask them, is it okay if I share these things? Even if you don't have that confidentiality duty, I think it's a nod to the child's growing independence and to their dignity to say, hey, am I allowed to share this? And what are the parameters of me sharing this? In independency, all the records are confidential as to the outside world, right? So that first section is people that have access to the Chapter 39 court file. And then we step down and we say all of those records are confidential. Everything held by the department is confidential pursuant to statute. And there are exemptions that authorize it, including the parent and their attorneys, any attorney representing a child in a civil or criminal contempt proceeding. So there are exemptions to that, but again, we need to look at it through the lens of, do I need to disclose? Is it necessary? Is it helpful? Is it allowed by the child? Does the child want me to disclose it? Non-parties trying to access the records must make an in-camera inspection only on a finding of a necessity prior to making a ruling on certain confidential records. So what would that look like? We'll see some case law citations, but in this statewide guardian ad litem versus Alberto, this was a 14-year-old child trying to protect her own therapy records. So therapy records, in my experience, are not generally part of the court file, and they're generally not part of the department's file, but they would be held by the therapist, him or herself. And let me see if I can, for some reason, there we go. My screen was locked up for a second there. Sorry about that. So let me go to the next slide. And I want to compare and contrast. This is about kids and child welfare primarily, but family law is a close cousin to dependency, and sometimes we have overlap. Sometimes we have cases that originate in family law and then they are transferred to dependency. And if they start out in dependency and get transferred to family law, we're not so worried about it, right? Because we have that confidential record protection. But when we're in Chapter 61 in family law, and if it starts out in family law, the records are generally not confidential. And I see this happening a lot with pro se litigants. We as attorneys, I know that we have a mix of attorneys and non-attorneys here. When we're filing evidence with the court, when I prepare for a trial, for example, I prepare all of my exhibits and I submit them to the court electronically in most in most of the counties and most of the circuit courts. We submit our evidence, but those are proposed, and sometimes they make it into evidence, and sometimes they do not. But what I see oftentimes with pro se litigants, or maybe sometimes somebody who is not it's really an administrative function to get evidence in. If your paralegal is not watching it, sometimes those exhibits get filed with the court. And in family law, if they get filed with the court, unless there's a corresponding alert to the clerk that it's a confidential record, it becomes a public record in some cases. So, if I was representing a parent in family court, for example, and they wanted to file therapy records or introduce therapy records of the child to say, bad things are happening at dad's house and child doesn't want to see dad. That might be an example of a therapy record that might be good evidence for one of the parties. But if you file it rather than put it in as a proposed exhibit, then those records could potentially become public record, and we don't want that to happen. So again, in family law, when we have litigants that are mom versus dad rather than DCF versus parents, the child ordinarily, unless they voice it in advance, they don't really, as a matter of course, they don't really weigh in on whether they want their record shared. But if you do some family law practicing, think about that before you utilize a record, particularly for older children, for teenagers. They may not want that record shared. And so that might be an appropriate usage of asking the court to appoint an attorney for the child in the family law court. And is there a least restrictive means? Can you and the opposing counsel stipulate to an in-camera review? Can you stipulate to any other means to which the evidence can come in without all of the therapy records coming in? I keep saying therapy records. It doesn't have to be therapy records, but that's a big one. Think about what happens when the case starts out in family law and is transferred to dependency. And so we have a question: how do you protect the child's right to weigh in on the records if they can't weigh in on who they want to live with? So you can have, in family court, you can have a guardian ad litem appointed. You can motion the court for a guardian ad litem. You can also motion the court for the child to testify, and the family court will determine whether the child is of sufficient maturity, intelligence, and the like to testify. So you can address it with the family court. And lastly, there should be an appointment of an attorney if there's records. The question was, how can they weigh in? They can weigh in by means of testimony, but as far as how can they weigh in on whether they want their records shared or not, I think if you're representing one of the parties, mom or dad, I think that you need to step lightly around those things before you release any records. You can get records perhaps, but if the child, in thinking about what things might be in there, right? Maybe mom or dad have an interest to see if the child is suicidal or if the child is going through something that the parent might want to know, but that puts a chill on what they disclose to the therapist. They may not open up to their therapist if they know that what they're going to say is going to be turned around and disclosed to mom or dad. I hope that answered it. But if not, we can circle back at the end of the presentation to go over any questions. And the privacy roots are a constitutional privilege, and so they apply in all applications, meaning Chapter 39 records have a presumption by statute. They're all confidential, whereas in 61, they aren't until that is asserted. However, because it's constitutionally based, it applies in every situation. And so our evidentiary, the rules of evidence say that there is a psychotherapist and patient privilege, and this does extend to children. It extends when a child is in therapy, it attaches. So as a general proposition, both parents can waive the claim for the child. However, When the parents themselves are involved in the litigation and they want to bring in therapy records to prove their case against one another, it's appropriate for the court to appoint an attorney for the child so that the child can assert that psychotherapist record privilege. And what these two cases stand for the proposition is that the first one, attorney ad litem for DK, and the parents of DK, when the parents themselves are litigants, they're not neutral. There's a tension there between the parents' need for the information to maybe prove their case or use it as evidence against the other parent versus what the therapy records were intended for in the first place, which is for the child to promote healing and to be able to freely speak to their therapist. And then this other case, SC versus the guardian ad litem, this stands for the proposition that this psychotherapist patient privilege applies to children's ability to keep the records from going to the guardian ad litem as well. So if a child doesn't want their record to be out there because the guardian ad litem doesn't have that traditional confidentiality client and attorney privilege, the child can assert the privilege against the guardian ad litem. So those are those two cases about psychotherapist patient privilege and how strong that right to privacy is. And now we're switching gears and talking about another, I kind of highlighted common rights that I see being either overlooked or coming up, right? When you're in court, these issues come up often. So right to access sibling and family. Under the normalcy laws, access to extended family is allowed. I think what's important to highlight is that kids don't know what they don't know. And so it's not just that family is being blocked, but they don't know that they can even ask for it. So when we talk about enforcement of children's rights, we're talking about making sure they know about these rights, making sure that they can self advocate and those around them, case managers, guardian ad litems, supportive adults, if they know these normalcy laws, they can help kids get these rights without anything formal going on in court, just showing up to court and saying, hey, I want to see Aunt so-and-so, or before I was in foster care, I had a really close relationship with this family member. And then when I got juggled around and I got moved, I lost touch. I would really like to see that person, or I'd really like to talk to that person on the phone, or I would like to have visits with that person. And I did want to mention that includes fictive kin. So it doesn't have to be strictly someone that is absolutely strictly by blood or by marriage. It can be fictive kin. It can be someone that the child is close with, even if it's not strictly related. One of the tips here is to get it court ordered. Things happen in the course of a case. People move, case managers change. Attorneys maybe move or rotate in and out. If you get it court ordered, it's part of the court file, and that will last longer than people's memories about it. So if you get it court ordered, it will live on. And the idea here too is that we don't know when we're working a dependency case how it will resolve. So if we get it court ordered, it can live on post closure of the case. In a permanent guardianship order, for example, or in an adoption. So be specific about the frequency, the duration, and the nature. Sometimes I've not so much anymore. We're in the post-COVID era, but there was a lot of argument as to whether or not a video, a session virtual, if that was counting as a visitation, because during lockdown and during times where personal contact was being limited, that was the next best thing. But I think it can be overused. And I think, especially with little children, we should do our level best to get an in-person visit and only a virtual when it's impossible, or and maybe a supplemental. I like it for supplemental, but not in lieu of. So get specific and in what you ask for, and put it in the order. And we have a question. Have you run into case management requiring fingerprints from relatives before they can visit? How do you navigate that, especially if there is a reason relatives don't want to do fingerprints? So no, actually, I haven't. I practice out of the 13th Judicial Circuit Court, and I have not seen uh, it maybe if they're going to a facility like a group home or something, but under the normalcy laws, there is no requirement to have a person be fingerprinted to visit with the child. I know Robin and I had a conversation about frequent visitors to the household, and that's really more so if they are going to be babysitting and spending lengthy periods of time with the child, like in charge of the child, maybe if like respite care type situations. But if it's, a person that is just a family member, they should be able to visit and see the child without being fingerprinted under the normalcy statutes. Again, if the child is in a specialized environment, like maybe a group home where it's on more of a tight facility, maybe the visit can happen outside of the facility if that's like one of the policies or one of the requirements of the facility itself. Know the child's schedule and talk it through with the child. I think this, again, through the lens of enforcement, um, if you haven't spoken to the child, or if you don't know what the child's the logistics are, I'm going to say, if you don't know, if you're asking for a sibling visitation, for example, and one child plays football, and the other child that is the other child that needs to visit is in band, or maybe works, maybe talking it through with the child would kind of shape the frequency and the duration and the nature. Like, how are we going to get this accomplished with everybody's schedules? When is the child available? And I think that is actually really great to put in the order too. I sometimes I see orders that say at a minimum of, once a week, or at a minimum of twice a month. If you can lock it down, all the better, because if it's locked in, chances of it happening are better. If you already know what the barriers are and you work around those barriers with your order drafting, then that's all the better. So think about the enforceability when you draft your motion. It's difficult if you have a rolling, hey, at least twice a month, but then maybe there was a holiday in there when the normal visitation happened. Draft around those sorts of things. Be very specific if you can. And, if you're having problems, these are just some brainstorming ideas that I've had. Do you want to be carbon copied when the visit is set up, so that you know if it is occurring or if it's not occurring? And if so, put it in the order. Do you want a visitation log to be created so that you know exactly when visitation is or isn't happening? I know that in almost all cases, they're tracking it for parents, but they're not necessarily tracking it for siblings to the letter, like they are if you're teeing something up for a termination of parental rights against the parents. They're Children's Legal Services and the department are very much tracking the visitation with the parents, but not necessarily with other relatives. So if you motion the court and you perceive that you're getting pushback, maybe ask for a visitation log to be emailed to you once a month or something like that. And then who may facilitate visits and who must facilitate visits. This is another thing. I mean, language matters, right? We're attorneys for the most part. I know we have some non-attorneys in here, but may or must is important. And I think again to the practical tip of knowing the geography, knowing the logistics, knowing the schedule. If we put it all in the department, the truth of the matter is that's going to reduce the amount of visitation that's going to happen. But if we put it in the order that a foster parent may facilitate, a member may facilitate, anyone that the child is comfortable with may facilitate a visit, or the relative can visit him or herself. And sometimes people just don't know what they don't know that they can. They don't know that they can go to the group home. They don't know that they can maybe ask to meet the child after school and take them out for ice cream and then drop them back off. They may not know that that's possible, so they may not even ask. But if you ask and if you brainstorm all of that in advance of your ask, then you can put yourself additional relief valves in your orders to say, DCF must facilitate a visit at, a minimum of this, but the relative may also visit the child in his or her home and may visit for an unlimited number of times, either in person or by virtual. Then you have it all laid out. So Jorge, if you can put up the next poll, do children that you work with have regular communication and visits with their siblings? And I would say, me on a personal note, I would, if I was going to answer this, I would say in between mostly and always. I think there's a pretty good track record of sibling visitation. I think the complications arise when the cases end.
And Christine, while that's coming in, I did put in the citation on the frequent visitor issue in the Q&A answer.
Awesome, thank you.
I'm going to drop it in the chat as well, just in case others cannot see it. And I dropped it there. And we have about 57%. I don't see more new answers, so I'm going to go ahead and end the poll and sharing the results.
So we have kind of a bell curve here. So that's, I would say the majority are having visits, at least sometimes, mostly, or always, which is, again, the minority with it never happening. And so if it's never happening, I would encourage you to explore what could be done about that. If the child, maybe it's because the child doesn't want to see their siblings. That's I would say, an unusual circumstance. Most of the kids I work with do want to see their siblings. And then I have a question. Any suggestions on competing interests for sibling visitation? Some siblings are being adopted, some are not. Someone visits and some do not. Yes, I think when the sibling separation happens, I think that's the time to talk about it, not at the final adoption hearing. But when you're doing the sibling separation staffing, there should always be an effort to place siblings together whenever possible. If it's a large sibling group, or if there's a reason for children to be separated and they cannot, those orders should be, that sibling visitation should be going on all throughout the case. And so it's hard for me to imagine a scenario where kids are visiting all along in the case, and then all of a sudden the child doesn't want to see their sibling. So I think those, again, I come at it from a child focused perspective. So if the child says, I want to see my sibling, then that's what I'll advocate for. If the child says, I don't want to see my sibling, then I think while the case is open, we say, well, what's going on? Why don't you want to see your sibling? Would you be interested in sibling therapy? I went to Florida Youth Shine is an affiliate group of Florida's Children First, and they're a group of amazing kids that have lived experience, and they convene all the time, and they work on issues that they would like to see worked on. And sibling visitation is one of the heartbreaker issues that comes to light with those kids, because if you're the oldest sibling and you age out, you're leaving behind siblings that are still in the system, and it may be difficult for you to visit. And they want, most of the kids that the young adults that I have talked to, they want to see their siblings, but sometimes maybe the younger siblings are with a relative, and the relative is not so fond of the older teenager who they view as a bad influence, for example. I would say that sibling therapy is a great idea, and even family therapy. If the relative is thinking, that older sibling's a bad egg, then let's work through it sooner than later. And I think those feelings come to light, and you sense the resistance during the course of the case. So handle it before you get to case closure is my best advice. A pound of prevention is worth an ounce of cure is how I look at it. And so with that, we'll go to the next slide. Actually, before we get there, let's go to the next poll, because this kind of hits on that last question. Do you promote post-adoption communication being included in the adoption orders? I think our cases close out with relatives in permanent permanent guardianship, or maybe in a non-relative situation. They age out or they go adoption. Good many of them go adoption. And so do you promote post-adoption communication in the orders? And we'll see what the audience says. I think sometimes there's not a smooth transition between what I have seen oftentimes is sort of a silo effect between the dependency and the adoption. And that's one of the things that we'll be talking about in July on one of our trainings, is how we can, one of the issues in the issue spotting is how do we get better at that? So Jorge, what are our poll results on the post-adoption communication?
Okay, I'm about to share the results. Here we go.
So interesting that I didn't know that I could on the post-adoption communication. I actually like that answer, because now you know that you can. So that makes me feel good that if one person attending today takes away one nugget, That's a good nugget to take away that you can. Now, we do have issues with standing sometimes. Standing in a sibling case. So I'm highlighting two case law citations here at the end of the slide here that we're looking at. That one came out of the Second District Court of Appeals and one out of the 6th DCA. And so it depends on the posture of the case if the siblings are parties to one another's case. So if I have an organic sibling group of 3, let's say, that all came into care at the same time, they're all parties to one another's case. So if they're parties to one another's case, they can file motions and they can participate in discovery. They can address the court directly through a motion, through their attorney, with their attorneys. And but sometimes if they aren't, if they aren't in the same case, maybe if a child is later born into the case, they maybe are assigned a different case number, and that happens sometimes by administrative order, just as a purely administrative function of the court, which I think is terrible that it affects substantive rights when it's just purely an administrative function, but it can happen. And so standing may prohibit your ability to introduce evidence. It never interferes with your ability to address the court. Siblings are participants by definition. You can file a motion to intervene, but you don't have to. By definition, siblings are participants to one another's cases. So you can address the court in the siblings case and say, hey, I would like a court order. So in the instance where maybe we have a teenager who ages out and they want to have visitation with their younger siblings, if they've aged out and their case is closed, they would not be, not necessarily, it depends, it's so factual based, but they may not be a party to their sibling's case. And so we have a case example here. Samantha aged out of foster care and is currently in PES. Her younger half siblings still have an open case placed with a relative who is supposed to facilitate sibling visits but isn't doing it. Can Samantha bring a direct motion, and can she participate in discovery, and can she maybe, and when I say participate in discovery, could she put the aunt on the stage, on the witness stand, and ask her why she isn't facilitating those visits? Taking testimony from a witness is a function of being able to introduce evidence. So can she, if she's in PES being after a case closes out and it's the college function that pays, I forget what the exact acronym is off the top of my head. It's post-education support services, I think. And in that case example, her case is closed. Her case is closed out, and she very well may be a participant rather than a party. But does the answer change if Samantha is in extended foster care? Yes, it does, because if she's in extended foster care, she still should have judicial reviews every 6 months. And so she still has an open case, and she can directly address the court, and she should be a party. So you can check those nuances, but just to alert you that they are there. The case citation for MS was a case where one sibling was trying to get visitation with a sibling who was adopted, and the Second District allowed an evidentiary hearing on the issue of sibling visitation. But in this other case that was out of the 6th District, which is actually one of Florida Children's first cases, they did not allow the introduction of evidence on the sibling visitation at the trial court level. We took it up on appeal. Unfortunately, the 6th District did not recognize the evidentiary right, but they did recognize the right to be heard. And they did recognize there was a motion to dismiss that was filed. They did recognize the right to have that issue up on appeal. So just to alert you that those are issues. check, which district you're in, and proceed accordingly. Next slide. Right to contact parents, siblings, and relatives post termination of parental rights. If the court terminates parental rights, it may order as appropriate. Oftentimes, what I see in a TPR proceeding is, as a matter of course, there is one last visit for the parent. But you can motion the court if your child has a strong bond. Maybe they're a teenager and they have a strong bond with the parent, and termination of parental rights has been ordered by the court. The court can consider whether continued communication is okay. They can decide whether or not it's letters, cards, telephone calls. And they can look at the nature and the frequency. It must be set forth in a written order, and it can be reviewed. So I have a child right now who is going to be 12 soon and does have post communication, post TPR communication with his mom. If he's placed for adoption, that is something we will review in a staffing in an ARC with the adoptive pre-adoptive parents. It's something that will be discussed. And it must be reviewed by the court at the time the child is placed for adoption. So all of these things, if we're going to talk about it in court, my opinion is you should be talking about it with the child. You should be talking about it in staffings before you get to court, so that hopefully we can get on the same page. But if not, you can advocate for what the child wants appropriately. And then we'll go to the next slide. Right. So the prior one was right to contact parents. This one is the right to contact siblings and relatives post-adoption as well. So we do have a statutory provision for the courts with the authority to order post-adoption communications with siblings with or without the adoptive parent's consent. So be aware of that. If siblings have been visiting the entire time, I think it should be put in the order so that kids can see each other, especially younger kids, maybe like middle-aged kids, 9, 10, 11. They know who their siblings are. They have a bond with those siblings. And then when they move on to adoption, if they're not being adopted with their sibling, if they have been seeing each other, it would be a great idea to put that in the post-adoption in the order so that it lives on in case the adults in the child's life get into a disagreement and they want to stop the sibling visitation. I know it's tough. I've done family law for a lot of years as well. And the answer for divorcing parents is never to not have communication with siblings or to cut ties. They have to figure it out, right? Divorcing parents they don't like each other for the most part, but they have to figure it out. And the same thing goes with post TPR or post adoption contact. If it's in the order, it has to happen. It becomes part of the final adoption order, and it's therefore enforceable. Although there is no specific enforcement mechanism included in the statute, I would rest on the court's inherent authority to enforce an order. That comes part and parcel with the court's inherent authority, and so put it in there, and maybe you be the first one to challenge it, and maybe make a law change to get it in there for the statute to have a specific enforcement mechanism. And then right to services, that's another one I think that we all spend a lot of time on. When you're asking for right to services, do your research, check statutes in the Florida Administrative Code as to do you really have a right to it? What does your right, what is it? What are you looking for? Is it therapy? Is it education? There's broad bodies of law that address a lot of these statutes and what the rights are. What does your child need? Be specific about what referral you are seeking ahead of time, and talk to a third party provider beforehand. Sometimes third party providers might have something specific that they want in their order. If you don't have a boilerplate, talk to the third party to see if there's anything specific that they need. We're doing a bonding and attachment study on one of the cases I'm working on, and I wanted to make sure that all the children were listed because I didn't want the bonding and attachment study to just be as to the older children. I wanted it to include all the children because there was a sibling group of 5. So, be nitty gritty on your orders. Know the possible barriers before you get into the weeds on your motion. If it's a resource desert, I'm fortunate to be in a metropolitan area. I'm in the Tampa area, and so we, for the most part, do have good resources. But if you live maybe in a rural area of Florida, I know in talking with others that sometimes there is a resource desert. And if your child, let's say, needs a particular specialist, I don't know, an audiologist or something, and there's not one in your county, the answer is, the answer is never, oh, we can't get it done. You have to figure out a way to get it done. Can you get transportation set up to something further away, something in another county, something that is a little bit away? I had a client that was in the Panhandle at one point, and we were able to set up. She herself was former foster child, and she had a young baby who had special needs, and we were able to get transportation to Shands from the Panhandle. So it's possible. Does the third party need something specific in the order? I already went over that. Can you get things expedited if specified in the court order? That's something you would want to talk about with your third party provider. What are their parameters for scooting you to the head of the line? Is it merely the squeaky wheel gets the grease? Or is it something, do they have criteria? Do they have something that scoots you to the head of the line? And if so, tease those things out so that if you do have a situation that needs expedited treatment, you can get it addressed in the court order. You can make your good cause maybe to the judge. Find out ahead of time, look at your case file, review some things. Maybe you can make a case for things to be expedited. And are there extraordinary costs that need to be addressed? Services cost money, and you want to know what, even if you want to know a ballpark, I think it's important to find out where is the source of revenue going to come for those services. Is it state funding? Is it federal funding? Is there some sort of pocket of money that can be tapped? Is there any other sort of cost? Is your case an extraordinary cost? Sometimes I've been appointed with foreign-born children that don't have immigration status, and therefore they don't have Medicaid. And so costs are a thing. We have to address those because it comes out of a different pocket. And just as a practical matter, ask the foster parents if they're willing to do some of the calling and legwork. I know some of the legal aid organizations, they do have social workers, or they might have interns, or they might have administrative staff. But not all legal aids and not all attorneys' offices have that ability to do the legwork, but maybe you can enlist the help of the foster parent. Maybe you can say, hey, can you pull this child's Medicaid and see who the providers are, and can you call them and see when's the quickest appointment that you can. I mean, a lot of our foster parents do that as a matter of course, but if they, let's say they have to find a specialist and there's not one in the county, can they call the next county over? Can, ask them to give them a little direction, ask them to do maybe a little bit of extra legwork if necessary, and offer to assist in the execution. If you're maybe an appointed attorney and you're on a flat fee, track your time, and there are mechanisms to get extra fees, but you do have to track your time. So that is an extra administrative layer, but it is possible to get extra fees so that you can get your child clients what they need. Break down into the task and get the tasks court ordered. We're going to go over the contempt slides in a minute, but I think that if you ask for something like the ICPC, know what those little tasks are that are intervening, break it down, and if possible, say, rather than just the ICPC has to be done, the order has to be signed within a certain amount of time. It has to be sent to Tallahassee within a certain amount of time. Get those in there so that you can kind of get some interim benchmarks. Ask for a staffing to be ordered and that you be invited, because we have a lot of participants. Know whether or not you are a mandatory participant in a staffing, know whether you're permissive. So if you're a relative that doesn't have the child, maybe you may attend a staffing, versus if you are a caregiver for a child, you must be invited, and the child should be invited. Ask for progress to be communicated to you. If you're going to try and hold somebody's feet to the fire on enforcement, ask the progress. If you set, maybe something needs to be done within 30 days. Ask for progress to be communicated to you informally, and offer yourself to be a barrier breaker. Say, I know it's tough. You might be running up into barriers. Please let me know. I'd like to get an email in a week. If there's any barriers, I'm happy to help. I think if you come alongside someone and offer your services to be a help, most times they'll take you up on it. And then right to access the court. Jorge, do we have our next polling question about, do the children you work with attend court regularly?
Yes, I'm about to launch it, but before I launch it, Christine, there's one question related to the previous slide,
Sure.
and I think it hits on one of the bullet points. The question is, if siblings are separated by significant mileage and the department says they can't facilitate transport, is there a fund or any way to help them get transportation for visits?
There's not a fund that I know of, but if it's court ordered, they have to. So I think I would maybe ask for a staffing on that specifically. I mean, again, I don't know the specific facts. Sometimes kids are placed out of county. Like, say for example, a case originates in one county, and one of the siblings is placed far away. I think everything is a matter of degrees, and how far is how far? Is it 4 hours away? Is it 30 minutes away? Are there any other, if DCF doesn't necessarily have a transport every single month, I don't think it's an appropriate answer to say they can never do sibling visitation. So I would say, what is the availability in that county? How many miles do we have? I don't know of a specific fund necessarily, but I think it's something that you could work on, but you would have to know what those barriers are, other than DCF doesn't have the resources. That I don't think that that's specific enough of an answer. So I would press and say, well, how many transport vans do you have? How many drivers do you have? Is there a vacancy? What's being done to fill the vacancy? Is it that they don't have vehicles? Is it they don't have staff? Like what's the resource desert there? And try and work through it. Is there anybody else in the child's life that can help transport? Do we have a teacher? Do we have a neighbor? Do we have a relative? Do we have anybody that can help make it happen? Can you solicit a church and say, hey, we have a sibling resource, we need a resource. Is there an old granny that is retired that can drive a kid from point A to point B? And can they plug in? I think mentors are one of the things. The Guardian Ad Litem, statewide Guardian Ad Litem program is really pushing mentors and supportive adults, and those people can help out too. So do we have polling results, Jorge, on whether or not children you work with regularly attend court?
Yes, we do. I'm going to end the poll and share the results. There we go.
Um, so do the children work with? Yes is in the minority. Yes, unless they're not asked to attend. Sometimes no and no idea. I think it's a mixed bag for my own personal clients. Sometimes they're not interested, but I think a reminder to them that the child shall be present unless the court finds that the child's mental or physical condition is such that a court appearance is not in the child's best interest. So sometimes I think it's a matter of they don't know they have court, or they don't know what's going to be discussed at court, or they simply don't. I mean, teenagers, maybe they don't want to be there. And so, but really, I think they should be encouraged to attend. And under the Florida rules of juvenile procedure, the court has to make a finding that it's not in their best interest or that their presence is waived. So for me, on my personal tips and tricks, we're all busy, and sometimes we might have a court hearing sneak up on us. And so the question, I'll put ticklers on my calendar to say, to remind me when the child has a next court hearing. So if they choose to attend, we can get transport set up for them. A lot of the times things are done virtually, and we should be offering the child a virtual attendance. I had a teenager client who, sometimes what I'll hear in court while I'm waiting for a Zoom or something is that, so and so had school. Well, I had a client who attended from school. We had him in a private office with set it up with the guidance office, and the child would pop in there and hang out in the guidance office until court started. I would text him and say, hey, court is starting, you can jump on. And or sometimes we would be in the virtual waiting room, and it would give us a chance to chat about things that might be discussed, at court, and if they wanted to address anything with the judge, communicate with the child on the types of things that will be discussed. And most of us are frequent flyers in court, and we know what the protocol is. We know what a judicial review looks like. We know what to expect. But I think if you tell a child what the lay of the land looks like and what's going to be discussed or what could be discussed, you can share those court documents and share the judicial review with them. Tell them this is what we're going to go over. I think if you ask a child in a vacuum, hey, do you have anything to talk to the court about or talk to the judge? Is there anything you want the judge to know? They're probably going to say no. But if you share some of the court documents and some of the staffing notes and some of the things that are talked about, if you share them and say, hey, this was what, these were the notes from the staffing, or this is what's going on in your case, in an age appropriate way, maybe that will spark their interest in attending court and participating, not just showing up, but actually participating. So again, it's interesting. A lot of these questions are bell curving. So I'm glad to see that we have a good amount of participation with kids in court and on the nose. I'm hoping that's because either the kids are too young to really have it be in their best interest, or that they simply really have a strong feeling that they don't want to participate in court, which happens. And so we'll go to the next slide. And if rights are not being honored before you go to the mattresses and file a motion for anything, even motion practice, not even contempt or compel or enforcement, but if those rights are not being identified, let's look at the substantive body of law that addresses that right. How is it an absolute right? Is it a policy? Is it statutory? Look at the statutes first, then look at the Florida Administrative Code on how it's being implemented. Is the right within Chapter 39, or is it somewhere else? If it's somewhere else, we're not all experts on everything. Seek outside assistance from colleagues. I'm going to give a plug for Robin because that's her superpower, is to connect people. She knows everybody around the state who are subject matter experts. And oftentimes she will know who to reach out to. So I'll let you contact Florida's Children First if you're in need of outside assistance from colleagues. That's another thing on the Florida Dependency website. We do have pro bono volunteers that can sign up on there. And if you are a subject matter expert on certain things, like if you're really good at ABA therapy, or if you're really good, if maybe you're doing dependency now, but you used to practice personal injury, sign up on that so that you could be a resource for other people. And you can seek out, we do get outside attorneys from outside practice areas that are willing to help out on certain specialized areas. So, find out what you don't know, and what are the barriers. I think that's really the key. What are the barriers that are keeping you from getting what you're asking for? Collaborate with the people on the team, ask for a staffing with the child's team, ask for follow-up, and often. We're all really busy, and I think the tendency is to scurry around before a court hearing. That's human nature. But if you ask for regular follow-up on an issue, if the issue is a home study, for example, and you represent a parent and the home study is not happening, maybe ask for weekly updates until that happens, and what the barriers are and why it's not happening. And these are just some nuts and bolts tips. Can you do it, or can you get it done? Robin mentioned that our next training is going to be on Social Security applications. If the case manager hasn't made the Social Security application, can you do it? Can you make the application? Can you get the record? If you're asking for particular records from a dentist or a doctor or whatever, can you assist? Maybe the foster parent is having trouble getting a record, and that maybe they need a record from a prior doctor, and they can't get to the specialist until they get that record. If they can't get it for whatever reason, can you assist? And then this goes to that question about the sibling visitation not happening. Can you get transportation from a foster parent, a relative, a mentor? Can you get it anywhere in the community? Is there a resource, not just money, but is there boots on the ground that you can tap into? A lot of times junior league, tap into your community. There's people that are looking to do service projects all the time, and maybe under the normalcy laws, you can build a bridge between one of those volunteers and your child, and maybe they can help get those barriers eliminated. And tips on your motion practice. You don't necessarily, when we're talking about motion practice, that's broad. That doesn't necessarily mean it is a motion to compel or it is a motion to enforce. It could be a motion for a referral for blah, blah, or a motion for sibling visitation. Just keep the enforcement in the back of your mind and be specific about the relief. What obstacles do you anticipate and draft around them? Draft the order with specificity and enforceability in mind. I think those of us who have practiced in family law, I think this becomes second nature because you anticipate what the other divorcing parent is. How are they going to be petty? What are they going to do to try? Most times in child welfare, I don't see people purposely trying to thwart court orders. There's barriers there, right? But when you kind of get in the habit of thinking about enforceability in advance, it helps you draft. Circulate the order to the case management and a copy to CLS. Case managers don't always get a copy of that order. So that's just a tip because maybe there's a lag in getting the order signed and getting it out to who's actually going to be the boots on the ground helping to assist with that. So here's an example on sibling visitation. Sibling visitation shall occur at a minimum of once per week. That's pretty good, but better, we say who's going to do it. The case manager shall schedule and facilitate sibling visitation between siblings so-and-so and so-and-so once per week. So now we have the kiddos that are named because maybe there's kids that have aged out, and what siblings are we talking about? And then we have something even more specific. Case manager shall schedule and transport an in-person sibling visitation between siblings Josh and Brittany once per week for a duration of no less than an hour. And if said visitation does not occur, the case manager shall alert the attorney for the child by email. So that then we know maybe the case manager will say, Josh was sick and so the visitation didn't happen. Okay, well, if there's a good reason why it didn't happen, then the follow-up would be, well, can we do it in another time when he gets better, or are we just going to wait for, if it's once per week, maybe it's reasonable to skip that week and wait to the next. But at least you'll know why before you get maybe several missed visitations in a row. Then we'll get into the contempt. This was an example. I saw this and I was nodding my head because yes, ICPCs take way too long. This was a case where an ICPC was taking, I don't know, when I saw this, I was like, wow, the court really held feet to the fire on this one because this was a case of a 2-year-old, and DCF sought approval to place with a child with the aunt in an out-of-state placement in New York. Under the ICPC, the court granted the motion and ordered that the child be placed with the aunt, but there was some issues with her being trained, and she also needed to have the training to qualify her for benefits for the kid. And in May 22nd, look at this this is to me, when I read this case, I thought to myself, there's got to be more to the story here, because from May 22nd to June 4th is a pretty short time frame, 2 weeks to comply. And when DCF didn't meet the deadline, the attorney ad litem filed a motion for contempt, and the court issued a show cause order requiring DCF to explain its noncompliance. It went up on appeal, and DCF had an explanation. So again, on the prior slides, know what the barriers are. DCF explained at the hearing it could not comply because New York wouldn't finalize the home approval until the training was complete and the finances were eligible. And I know there's workarounds. You can send a child up for a 30-day visit, and you can do that in the hopes that you don't have to send them back. But the administrative rules were barring the out-of-state placement, and that was the barrier, and therefore Florida caregiver benefits couldn't be paid out. And so the holding on that one was the court reversed the trial court's contempt order because it did not contain the requisite finding that DCF had the ability to comply. So if you don't know the barriers, you don't know. You're kind of jumping the gun on a motion for contempt. If you don't know the barriers, you don't know whether they could comply or they couldn't comply. So that's an important, I think probably the most important thing that you need to know on contempt motions is that you have to know whether they could or could not comply. And the ability to comply, if you have to prove those that ability, then you got to know what those barriers are, address those barriers before you waste your time bringing a motion, and ask for a staffing so that you can get the whole entire team together where brainstorming can happen, less finger pointing, more problem solving. And if you have everybody at the table, it will save you a lot of phone calling and a lot of emailing. If everybody is gathered around, I think it's the most efficient way. And so here I have a series of slides on contempt and things to keep in mind. These were contempt was found, but the appellate courts had issue with the appropriate sanctions. So in our first case, the Department of Children and Family Services versus JB, this was an issue of a home study that had not been timely completed. And after 5 weeks, the mom's attorney filed a petition for an order to show cause. And importantly, the petition did not seek attorney's fees. And at the hearing on the petition, the court kind of invited it and said, hey, do you want to seek fees? And then awarded them, consistent with the attorney's fee affidavit. The district court said, no, you can't do that because the petition did not plead for it. So if you don't plead for it, you don't get it. If you don't ask for it in your pleadings, you can't get it. It's a due process violation. It didn't put DCF on notice that fees were being sought. So that's a no-no. The next one, Department of Children and Families versus DT. The department violated their court's order to file and serve a predisposition order within 5 days. And the court, as a sanction, said that the representatives of the department were going to perform 1,000 hours of community service or pay a coercive fine of $1,000. And the court had two problems with this. It said that they sanctioned the wrong parties because instead of the actual attorneys, it was representatives of the department. And so they said, no, you can't do that. And so the sanction was on the wrong party, and the court exceeded its authority when it ordered the fees. So both of those, the contempt was upheld, but you've got to really follow the letter of the law when, and again, think about what you're asking for in your drafting, because if you didn't ask for it in your drafting of the motion, the court can't give it to you. And if the court does, it's going to be reversed. So in this case, I'm not so sure. The case law on this one was really short. It didn't say who asked for it or if the court just came up with that sanction on their own. But nevertheless, it was inappropriate. Then we have constitutional considerations. being that the court is the judicial branch, and the other powers from DCF are found in the legislative branch. No branch may encroach upon the powers of another, and no branch may delegate to another branch its constitutionally assigned power. How does that play out? It happens more often than not with money. Or specific placements. So in this particular case, on the MH case, there were juveniles in delinquency that were in a secure residential treatment program. And after they had been in county detention council, moved the circuit court to compel a certain placement. And the circuit court granted that and ordered the DCF to place the children. And based on the separation of powers doctrine, the court cannot compel DCF to place a child in a specific program when the space is simply not available. So again, do your homework, know what's available in your area, and if it's not available in your area, go wider. Is there anything in the next county over or the next county over, and see what you can do to make it enforceable. The next one here, MM had been adjudicated dependent and was living in a residential sex offender program. There was a hearing and a recommendation to step him down. And when that step down didn't happen, the court had ordered for the step down into a therapeutic foster home. And again, we had unavailability of a foster home, and the department was unable to comply with the trial court's order. So again, you've got to know, make the case. That's why I kind of like the idea of a check-in. What's the progress? Who did you call? And I want to know, not just to hold somebody's feet to the fire, but I don't want to do duplicative work. So if I have a case manager, I had a kid that was, or a young adult that was looking for an extended foster care placement, and they were scarce, right? And so I said, can you email me who you checked with? Because I'm going to cast a broad net and I don't want to do duplicate work. Can you tell me who you contacted? And that way, if I see the list, I won't do double the effort. I won't contact the people that you've already contacted, because what's the point? And that's kind of a collaborative, cooperative way to find out who have you called, what resources have you tapped, so that we know it's not just a shrug of the shoulders and, oh, there's nothing available. And this is an extraordinary relief, the writ of mandamus. That's used when the government has a very clear duty to perform something and they're not doing it. So this case was one county over from me, out of Polk County, when the trial court delayed entry of a dependency order for 27 months. The father filed a writ of mandamus and asked the court to issue a ruling. This is crazy to me that there was no order issued by the judge within 27 months. And it was crazy to the appellate court too, because they vacated all of the trial court's orders and entered an order remanding to the chief judge and said, we want you to reassign this case. Don't give it back to the prior judge. We want you as the chief judge to give it to another judge. So that one, that's I think 27 months is pretty extreme. So that was an example of one mandamus. There was a clear duty for an order to be entered, and it wasn't happening. This next one is on records. So every child in foster care has a right to their records pursuant to 39.00145, and they have a right to it for their record without charge. However, in this particular case, what it turned on was DT, the young person. He wanted all text messages and he wanted all emails, not just what was in the case record maintained by DCF, but he wanted the entire physical and electronic welfare at no cost. And yes, they did have to provide it, but it turned on whether or not they could charge for it. And unfortunately for DT, the court upheld that, saying, yes, mandamus is appropriate because the child has a right to his or her record, but just not everything so with its entirety for free. Some records they can charge for. And so with that, before I get to the next slide, we'll put the next two polls. I probably should have spaced them out. Sorry for that. But I'm interested to know what areas have enforcement been an issue in your practice? Has it been obtaining services? Has it been visitation? Has it been placement, normalcy, or something else? I tried to tailor this to what I ordinarily see in court, but I'm only one attorney, so I'm very interested to know what other attorneys are spending time on, where what things need greased. So that we can be a resource and be a resource for each other. I don't have all the answers. I don't pretend to. That's why I love the idea of collaboration and talking with other attorneys who do this work. And I'm interested to know what other issues are giving people heartburn.
Right, so we have a 42% participation. So I know we have another one, so I'm going to end this one right now. It seems pretty split up. Let's share the results.
Okay, so we have kind of a wide variety, and only 7% on something other. So it seems like I did hit the major areas, with the leading being family and sibling parental visitation. Okay, well, I would encourage you to go back to the prior presentation, and those have all the statutory references as to how you can get what you're looking for. I would, without knowing each individual facts, it's hard to give tips and tricks that are very specific to your case, but you're always welcome to reach out to us, and we're happy to help in any way that we can. And if you've had enforcement issues, next poll, how did you resolve them? In many years of practice, I've only had to do contempt once, and if you've had enforcement issues, how did you resolve them? Was it informal? Was it creative? Ordinary motion practice, so that would be a motion for sibling visitation, or a motion for whatever, before you get to a motion to compel, or before you get to a contempt or a writ, which is the more extreme versions of enforcement. So what has been your experiences?
Right, so we're about 30%. So far, the most popular one seems to be informally, but it's really close to ordinary motion practice. So I'm gonna go ahead and close it out in three, two, one, and let's see the results.
Okay, so I think it's almost split between the informal and ordinary motion practice. I would say, let's all work on our creative solutions then. If I mean, 38% is a big margin, so that's encouraging to me. I like that because, and that's why I think the staffings are key, because that gets more people at the table. People with different levels of experience with different things. And I think the more brains that are working on a problem, the more solutions we can generate. And that's it for the slides. I'll get them. I think I already sent them to Jorge, so he can get those out to everyone who attended or registered fairly quickly. And think we are doing pretty good on time.
Yeah, we're only 1 minute over, and this was a lot of material. Great presentation, Christine. I'm going to read out the CLE code out loud for the benefit of the audience. I already dropped it into the chat. This will go out via email, and it will also be in the YouTube description. Same as the materials, there's a materials folder link where you're going to find a PDF version of this presentation. The CLE code is 2600668N. If you need a certificate of attendance or a certificate of completion, if you watch it after the fact, feel free to email me. I'll start working on those as soon as they start piling up. I did drop a link to our YouTube playlist for the webinars, but as Janine also mentioned, you can subscribe to our YouTube channel. That way, every time we post a webinar, you get notified automatically. And I will also drop the link for our next webinar for this series, which will be March 18th, Wednesday. So you can register directly in that link. But if you miss it, don't worry because I'm going to include it in the email that goes out from Zoom. I know we're a little bit over time. I do not see any pending questions. If for whatever reason we missed a question, feel free to email me and I'll make sure I can pass it on to Christine and Robin. So, as going back to Christine, thank you again for an amazing presentation. I mean, I know I've worked with Christine and Robin multiple times, and they always do a great job. So, thank you to Florida Children's First for partnering with us for this great series and for the public interest law section, particularly the Children's Rights Work Group for putting all these webinars together. So with that said, have a great rest of your day, everybody. Thank you, Christine. Thank you, everybody that showed up, and I'll see you at the next one.
Thank you.